Appeal number 36, Kimmel versus the State of New York. Counsel?
Good afternoon. May it please the court, my name is Mitch Banis. I represent the appellants, the State of New York and State Police. I would, with the court's permission, request to reserve 3 minutes for rebuttal.
You may have 3 minutes, sir.
Thank you. The issue on this appeal is whether CPLR Article 86 applies to actions seeking purely monetary damages. CPLR 8602A contains a definition of civil action and defines the civil action to which the statute applies as any action or proceeding brought to seek judicial review of state action. Judicial review, of course, is a term of art. Is a definite, precise meaning. It's been supplied by the case law for hundreds of years, and it refers to oversight by the courts of the executive and legislative branches. If judicial review meant simply...
The respondents question the validity of your statement that somehow judicial review is limited in the fashion that you claim that it is. Particularly, they make much of your failure to refute the definition of this court of the term judicial review in the Pan Am versus Division of Human Rights case. Do you want to address that?
I'd love to address that, Judge. The Pan Am case, first of all, was not an Article 86 case. So the court was not addressing whether or not Article 86 applied in that case. To the extent that the court in Pan American does use the term judicial review, it's really in dicta. It's not stating a broad proposition of law, and it certainly was not departing from hundreds of years of precedent.
But it was a civil rights action, much like this one, right? State
Yes.
Division of Human Rights case.
Right, it was, Judge. But then in later cases, the Marine Midland case and the New York City Department of Environmental Protection cases, this court, I wouldn't say retreated, but used a different language in referring to the type of actions to which those statutes applied, and backed off from the use of the term judicial review in favor of using phrases like judicial actions or judicial forums. And actually, the court in both the Marine Midland case and in the New York City Department of Environmental Protection case cited this court's decision in Pan American for the textbook definition of judicial review. So I submit, Judge, that this court's use of the term judicial review in the Pan American case is in no respect dispositive of
Why do
the
you
issue on
think?
appeal.
Why do you think that it is a term of art? I mean, I know you go back to Marbury versus Madison, but even in that context, it is used not in terms of reviewing administrative determinations, but in our branch of government reviewing what the legislature and the executive branch does or do.
The words judicial and review, when you are commonly used in conjunction to mean administrative, review by the courts of administrative determinations, rules, and decisions. When
But you concede that that's not what Marbury versus Madison talked about. It wasn't review. It wasn't judicial review of an administrative determination. It was judicial review of conduct or actions by two different branches of government.
Well, exactly, Judge. Yes, I absolutely agree with that. But the point is more that it's the judiciary reviewing the actions of either the legislative or the executive/administrative branches. That's where the concept of judicial review acquires rather its specialized meaning as a term of art.
Supposing a plaintiff had brought a human rights law action as a class action seeking injunctive relief, maybe the appointment of a monitor, sort of an institutional reform action, what's your position there as to whether then they'd be allowed to proceed or not proceed? That is, Could they recover fees in that circumstance?
I don't think so, Judge. The reason being that in the action you described, the object of the statute, as I understood the object of the action, as I understood your question, was monetary relief.
No. With the injunctive purely.
Purely injunctive relief? I believe that, Judge, yes.
To stop discriminating, to appoint a monitor to review decisions about promotions, about work assignments, that sort of thing. Purely injunctive.
I think so, Judge.
When you say you think so, you think what?
I'm sorry, that Article 86 would apply in such a situation.
That you could recover fees under the AJA?
Correct.
Okay. And that fits within your definition of judicial review?
Yes, it does, Judge, because
Now, if we then add to that a money damage claim as well, so we have the same request for injunctive relief, but we've added a money damage claim, does that change things?
And the litigant prevails on both claims?
Let's say yes for the moment.
Okay. I would think for those fees that would be attributable to the injunctive relief, yes.
And if the litigant prevailed only on the injunctive claims, then all the fees, I take it is how you'd answer that.
I think so, Judge. I mean, I know there's a body of case law that sort of requires a court in reviewing the reasonableness of fees to kind of parse out, to what extent did the litigant prevail on one issue versus another? What were the fees?
All right, but at least in terms of entitlement to some fees under the AJA, there'd be some.
I think so, Judge, yes. Because again, you're talking about the judiciary overseeing the other coordinate branches of government.
Via injunctive relief.
Correct, yes.
That can never happen in an action under your view of this statute.
In an action for monetary damages?
In an action where there might be both monetary damages and other relief.
And what would not happen? I'm sorry, I'm not following the question.
And non-monetary relief. If there is an action for injunctive relief, that's still an action, right?
Yes, it is, yes, yes. But it's an action if you're looking, if the plaintiff is looking for injunctive relief, then it's seeking judicial review. And then that's what distinguishes that situation from the situation at
Well,
bar.
my understanding is the plaintiff here did bring claims for injunctive relief, but she was frustrated in those claims by the state's actions.
Well, I disagree with that characterization. But the fact of the matter is that this plaintiff did not pursue those claims for injunctive relief. And I don't think you can invoke the benefits of Article 86 of the CPLR merely by including a claim for injunctive relief, which you don't either ultimately pursue or prevail on. Here, the plaintiff prevailed only on the claim for monetary damages.
Thank you, counsel.
Thank you.
Mr. Bizarre?
Oh, I'm sorry. Thank you.
Good afternoon.
Good afternoon.
May it please the court, my name is Vince Bizarre, and I'm here representing the plaintiff, Betty Kimmel, the state trooper, and her two former employees. She did bring an action for both, and the reason she didn't pursue or insist upon an injunction was it was 12 years later after she was out of there. She was gone. She wanted an injunction. She wanted to be reinstated. It was moot by the time she got there. It was an action for both.
Counsel, I'm sorry, to change topics a little bit, one of, I think, your arguments is the Court of Claims carve-out in the statute.
Yes.
And if we read it the way your opponent reads it, it's unnecessary.
Yes.
But it seems to me the Court of Claims already has a provision that provides that you can't be awarded attorney's fees in that court. So why would you need to carve out anyway, even under your theory?
Well, I have turned the table. If it also makes no sense to say that the legislature intended to limit the matters to be reviewed to declaratory judgment actions and Article 78 proceedings when they can't be brought there in the first place. They can't be brought there. And administrative and an action.
Right, but I think the point would be, it doesn't matter either way, because you wouldn't get attorney's fees in the Court of Claims anyway. So if they didn't carve it out, it would be the same effect. So it seems to me there's no basis for a Court of Claims carve out, either one that supports your opponent's view or one that supports your view.
Well, I stick with my description because I can't tell you whether or not there are some situations where legal fees can be collected.
Let me ask you, why would the statute be such that if you brought a claim for money damages in the Court of Claims, you could not get attorney's fees, but if you brought that same action in Supreme Court, you could? What would be the rationale behind that?
Well, as it applies to actions under the human rights law, you have a right to bring it under either.
But then why would anybody ever bring it in the Court of Claims?
Well, you may not want to bring an action for human rights in the Court of Claims, but there are other kinds of actions, of course. The Court of Claims applies primarily to torts and other kinds of cases where there are contingent fees, primarily torts. In the human rights cases, the contingent fee is not adequate. We've demonstrated that here. So in the Court of Claims...
I'm sorry, counsel, why would it not be adequate? There's never been an award of attorney's fees in these cases before this that anyone can find. So that would mean no one's bringing human rights contingency cases?
Well, my understanding is very few. The record indicates, Mr. Bannis contests it, but the record indicates that she tried, at Appendix 597, she interviewed 7 lawyers. And this case is a good example, and they refused to take it. Here's a good example of why. The jury verdict was $720,000. The claimed legal fees were well in excess of $1 million. The agreed reasonable fees by the state are over $800,000. Private lawyers are not going to take cases where the state has the power to end up paying 25 cents on the dollar.
We can agree that these are particularly egregious facts and dilatory tactics and all the things you outline in your brief. It seems to me one of the main purposes of the statute, though, is to give an incentive to people to bring these lawsuits. This was a $15 million contingency claim. So 12 years later, you're talking about what the fees are, but in terms of access to justice, getting someone to file a $15 million contingency human rights lawsuit?
Well, if you're saying $15 million because that's what they put in the complaint, I mean, that's neither here nor there. The fact is she tried 5 or 6 lawyers. She got $700,000, and the legal fees, as reduced, were in excess of that. So it is a blocking of access. And if I may say, this court in December in Diggleman reinforced and reiterated the rule that remedial actions are statutes which are remedial are intended to be read broadly, not restrictively. This is a remedial action. The FEJA has been held to be remedial, rather than, therefore, becoming, we have to read the words, but in case of doubt, it ought to be resolved in favor of the plaintiff, or of Mrs. Kimmel and others similarly situated. Here, the state is trying to take the word judicial review, which do not have an established meaning, which I'd like to talk about in a second, and put in words that aren't there to make it, they make the words any civil action mean declaratory judgment actions. And that's a very narrow bar.
Why has no court, and apparently no plaintiff, asked for these type of fees in the past if the statute is that clear? And while you're thinking about the answer to that, there's a provision for reports in this statute. I think it's 8604. I looked at all the reports that are available. They're all declaratory judgment type actions, all Article 78s. So nowhere in the history of this statute as applied, as the appellate division dissenters pointed out, or in the reporting from the statute itself, has there ever been a case where attorney's fees were awarded?
They may not have been able to find a lawyer to bring the case in the first place. Go to the administrative.
So this is the only human rights
where you
case
get less
in the
damages.
book. So this is the only human rights case
What's that?
on the books. This is the only human rights case like this on the books. Is your point? Because the other ones they didn't find
Well,
lawyers
that was
to
your
file.
point, but I'm saying one explanation, and I'm not sure you can take what's happened after to infer legislative intent. Maybe nobody was smart enough to do this, or because the stakes were so high for this person. The other thing,
are you familiar with any action using the private right of action under the state human rights law where you've had an award of $12 million?
no.
Okay,
No, but I haven't. I must say I haven't searched.
okay.
But
If we think that the legislative history is not clear,
yes,
what is your response to the state's argument that when you look at the legislative history, particularly the prior attempts, it really looks as if this is meant to reach regulatory action, to give people incentive to challenge that?
well, that's a very good question because there's nothing in the state makes a big thing about the legislative record, but there's nothing in the legislative record that says that it's limited to administrative actions. This whole judicial review construct that they've come up with, it's not in the legislative history. The early legislative history, the earlier bills were for clearly administrative. They were in the Administrative Procedures Act. They said they applied to agencies. All that's left out. There's nothing in here limiting this to this statute as written and adopted.
Is there
administrative.
any part of the legislative history? I mean, I looked at the,
Yes.
for example, the letters from the sponsors of the bill, the support memorandum, and they all seem to refer to a civil action brought against the state without the limitation of judicial review that the appellants seem to bring in.
Absolutely right, Your Honor. And I would direct you particularly to the legislative sponsors memorandum in the Assembly, which repeatedly refers to any civil action without limitations.
This is the September 2189 letter to the governor from the sponsor
No,
of the
this
bill?
is at Appendix 551, the memorandum of support from the legislature. May I use my final minute here
Certainly.
to talk about this business of what judicial review means? The federal statute, when it said, referred to judicial review, it didn't say that it was implied. The state's saying that it's implied, it's implicit. That means implied without expressing the words. That when the feds wrote their statute, they said, including judicial review of administrative agencies. All of the state cases, which the state cited for the proposition that in other states judicial review is limited to administrative actions, it said administrative actions.
Can't that be interpreted two ways, though? Can it be interpreted that the state didn't say that? Could have said exactly what the federal statute said, but didn't. So maybe they intentionally left out.
Yes. Well, that supports our position. The state that's exactly our position. The state intentionally left out the words administrative review,
Well, no,
thereby not limiting it.
Left out including administrative review, thereby indicating that they were not including.
No, the
Oh,
feds
I'm sorry.
The federals did include,
Yeah.
but that also doesn't explain it
I'm
with,
sorry, to make it clear that it was not just administrative review. I misspoke.
well, that doesn't explain, I don't agree with that.
No, I know, but I'm just saying that could be another interpretation.
I think the fact they left it out is very instructive, as is the situation with the other state actions, all the other state statutes which are limited to administrative review, so state, and they're trying to insert words into it. And there's no better case to fulfill the purpose of this statute than this case, to open up the courthouse doors to people like Ms. Kimmel. Thank you very much.
Thank you, Mr. Bizarre. Mr. Banas?
Thank you.
Mr. Bennis, would you address that federal, state
Sure, and I was going to.
statute issue?
So thank you. Yes, this court in the New York State Clinical Laboratories case noted that while there are some similarities between the federal EAJA and the state statute that we're looking at here, there are some critical differences. One of those differences is in the way in which the respective statutes address the judicial review issue. Under the federal statute, there's a presumption that all actions are included, except tort cases, which is kind of where we get, I think, our court of claims exception, including actions for judicial review. So under the federal scheme, actions seeking judicial review are a subset of the actions to which the statute applies, whereas under the state scheme...
Isn't that in response to case law? Wasn't that in response to case law?
What do you mean?
Wasn't that in response to a particular interpretation that the legislation was addressing?
You mean the state legislation?
No, the federal.
Oh,
Okay, go ahead.
I'm not for that case. I apologize, Your Honor. But in any case, under the state scheme, the actions seeking judicial review are the entire universe of actions to which the statute applies.
You don't dispute that this is a remedial statute, as the respondents contend, right? So it should be interpreted broad to carry out the purposes of.
Well, I think there you've got two competing canons of statutory construction in play. One is, yes, to a certain extent it is remedial, but also it's in derogation of the common law. So you've got the canon of statutory construction, which requires the statute in derogation of the common law to be...
But once it is determined to be remedial, we have to interpret it broadly. Isn't that what this court's precedent is?
I don't think so, Judge, and here's why. If the statute had a broad remedial purpose, if the intent was to level the playing field for litigants against the state generally, then you wouldn't have the court of claims exception. I mean, the court of claims is where the vast majority of actions seeking money damages against the state are brought.
Those are tort actions, aren't they, generally, counsel, not human rights law violation actions?
Well, then we get back to the concurrent jurisdiction issue, and is there any indication in the legislative history that the legislature intended to make the state the only entity subject to a fee award in human rights law cases? And there's no suggestion of that.
Most cases are brought administratively within the agency. In fact, if you look at the number of cases that are brought in court pursuant to this private right of action under the executive law, that's minimal in comparing it to the administrative proceedings that are brought.
That's
right?
probably true.
So it's not rare. I mean, it's not remarkable that we don't have cases using the Equal Access to Justice Act, where most human rights law cases are brought administratively.
Well, I don't know if it's not rare. The fact of the matter is, in setting the proportions aside, there are many discrimination suits that are brought under the human rights law.
Not many succeed, if you're really going to count the numbers.
Yeah.
No,
You're really going to count the numbers. The opportunity
but
for this
they are
kind of a
broad.
case, this particular kind of case, considering the time frame, is almost zero.
But the last thing I'd like to point out on that, though, is that the human rights law under which this action was brought does use the term judicial review, and it defines judicial review or prescribes the means by which to bring judicial review of an adverse decision by the Human Rights Department. And what it talks about there is exactly the type of action to which I submit the statute was intended to apply, which is an Article 78 proceeding brought to set aside the determination as arbitrary and capricious.
Thank you, counsel.
Thank you.